Good day, Crime Talk aficionados. We have another great show for you today. But guess what? Nick Reiner really hated his dad, according to one of his rehab buddies. A federal judge has ruled that Luigi Mangione will not face the death penalty, but he got a little other bad news. Why the multiple killer theory in the Koberger matter just doesn't hold water. Brendan Banfield. The jury is deliberating after some not so great closing arguments. The Epstein files have been released. We've got this day in legal history, our quote of the day, and our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. Now, you know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and hit that little bell for notifications. And, you know, if you want to listen to us on any of your favorite podcasting apps, you can do that as well. Now, you may say, what is this assortment of, I don't know, self-defense material in front of me? Pepper spray? Look at this can. Nobody's going to mess with you with this can of pepper spray. I mean, you can take this for, you know, the dog walk, little home security, maybe your little peaceful demonstration, if that's what you wanted to do. Look at that thing. Then we got little smaller sizes here, right? This is all from a company called Police Magnum. All right. They sent us this stuff to let you be aware of it. All right. You want to go out for a run? Like I said, go walk the dog, have a little pepper spray on you right there. Different colors, different sizes. It's great. Oh, you not sure you want to have pepper spray, but if something happens, you want to be able to, you know, have somebody know where you are. Try one of these. That's going to get somebody's attention if they're doing something to you. Take a look at this. Now, this is personally my favorite that I like. Look at this. Nice, compact. What does it look like? Looks like, I don't know. Gee, I don't know. Could it be something like, oh yeah, look at that baton that where you can whack somebody upside the head if you had to, ladies and gentlemen, in self-defense purposes only. And then you just tap it down on the ground and look, it goes right back up into the real size. But let's face it, you're sitting there minding your own business, walking along. Somebody tries to do something to you. You're like, oh no, hold on 1 second, please. Whack, crack them across the head. They're not going to mess with you anymore. So go to Police Magnum. And listen, I get nothing out of this. This is all for you. They sent it to us, but they're willing to offer you 10% off when you use the code Crime Talk and free shipping. Oh, and look at this. Apparently, if you want to cuff the bad guy because you have completely incapacitated them with the pepper spray or the baton, you can even throw on a pair of handcuffs. They'll sell you a pair of handcuffs. Who knew? Anyway, go check them out. 10% off, free shipping. All right, so let's go ahead and get to today's docket for January 30th, 2026. And can I just take a moment here and say, has this January gone by so incredibly fast? Yes, it has. I was supposed to be in a homicide trial this week. I was supposed to have a light week. I have been busier. It would have been easier for me to be in trial. But the month is almost over. We will begin again next week will be February, if you can already believe that. All right, first on the docket, Nick Reiner really hated his dad. All right. So about a month after Nick Reiner's allegedly stabbed his parents to death in their $13.5 million Brentwood home, more details are emerging about the state of mind leading up to the murders. Now, Nick remains in custody. Obviously, he's there without bail at the Twin Towers Correctional Facility in Los Angeles, and he has not yet entered into any type of a plea. He hasn't said not guilty. We haven't got to arraignment because, frankly, they think he's not going to be competent. Now, sources apparently close to the case indicate that he has been diagnosed with schizoaffective disorder, a serious condition involving symptoms of both psychosis and mood disorders like bipolar or depression. Now, roughly a month before the killings, his medications had been adjusted, but was apparently unhappy with the weight he was gaining because of the medications. And according to one insider, once that happened, he went completely off the rails. Now, if you gain a couple of pounds, we get it. Maybe it's a little water weight, maybe go walk it off a little bit. No. Going to kill your parents, not the appropriate thing to do. Just Just going on a limb there. That's all I'm saying. Anyway, it's still unclear whether Nick was using drugs again at the time of the murders, because if he was, that kind of takes away the NGRI, let's face it. And he also has a long history of substance abuse, which would make it somewhat plausible that he was high as a kite. And he also had 18 stints in rehab, and obviously he's a high rep learner. He once described himself in rehab as a nutcase. Now, some believe a relapse combined with the medication change may have triggered his violent episode fueled by meth or similar substances. Now, obviously, the murder weapon, it's unclear whether it's been recovered, but there are lots of sharp objects in the house for sure. Anyway, so this same source describes Nick as, quote, totally detached from reality, end quote, and he is completely unable to fully grasp what he is being accused of doing. And as we know, Alan Jackson withdrew from the case back on January 7th, and now he is being represented by the public defender. So perhaps the most striking news account comes from a guy by the name of Danny Sivler, a Wyoming resident who shared a room with Nick at his upscale Malibu rehab facility when they were just 15. He spoke to the Daily Mail, and Mr. Sivler said that the moment he heard about the murders of Rob Reiner and his wife, he immediately knew who was responsible. Now, this guy says, I would hate to see Nick try to plead guilty or not guilty by reason of insanity, this guy says, when in reality, he told me how much he effing hated his parents, especially his father. So, despite that resentment, Sivler emphasized that Rob, then in his 70s, and Michelle did everything possible to support their son. He says they were there for them at every single family group session and every therapy session. They didn't have to give me the time of day, but he played Frisbee with Rob Reiner. For God's sakes, they just wanted him to get well. The roommate originally described Nick as initially welcoming and funny, but with a side that could flip rather quickly. Their rapport soured after the roommate innocently compared Nick's appearance to Jet Travolta. Yeah, John Travolta's late son, which prompted an aggressive reaction. Nick got in his face, raised a fist, and required a staff intervention. Anyway, apparently there were some late night conversations after the lights went out, and Silva left Mr. Sivler unsettled. As a 15-year-old dealing with his own shopping addiction, he found some of Nick's disclosures very, very chilling. Now, years later, learning of the stabbing, where Rob and Michelle were reportedly attacked in separate rooms while awake, left this roommate chilled to the bone. He reached out to mutual contacts from the rehab days, and everybody knew it was him. Anyway, Sivler stressed that this is a profound Hollywood tragedy. Rob and Michelle loved Nick and did everything that they could for him. They just wanted him to be well, and he did not want to be well, according to this gentleman. Now, Nick's arraignment is set for February 23rd, and a family spokesperson has stated that the Reiners have the, quote, utmost trust in the legal process, end quote. It's funny when people come out of the woodwork like this to tell about their interactions with somebody that's accused of doing something wrong, or obviously somebody that's deceased, since he knew the Reiners as well, the parents. But you want to know whether they really, are they looking for their 15 minutes of fame? Did the Daily Mail reach out to them? You got to take all of that with a somewhat grain of salt, but it does show that there's a lot of animosity there. Now, in the movie that Nick Reiner wrote and his dad directed and helped produce, it was obvious that he and his dad were not pals. They were not good friends at all. And, Nick Reiner from there just seemed like he wanted to do whatever he wanted to do and not what anybody else wanted to do. And the rules didn't really apply to him because he thought, well, frankly, that he was kind of privileged. So anyway. Next on the docket, a federal judge has ruled that Luigi Mangione will not face the death penalty. Yep. So, U.S. District Court Judge Margaret Garnett dismissed 2 key federal counts against Mangione on Friday, including the murder charge that carried the possibility of capital punishment. Now, the judge determined that stalking, the underlying offense prosecutors relied on, does not qualify as a crime of violence under federal statutes, making the death penalty eligible charges legally incompatible. Now, as a result, the federal case now proceeds only on stalking-related counts, which carry a maximum sentence of life in prison without parole. Now, Mangione remains charged with murder in the New York State court, where the death penalty is not an option either. And in a separate but related development, prosecutors secured a bit of a win in front of Judge Garnett, who ruled that the evidence seized from Mangione's backpack during the December 2024 arrest in Altoona, Pennsylvania, is admissible at trial. Now, I hate to say, gee, I was right, but I was right. It's completely reasonable seizure and search of his items there at the McDonald's. I would have been more surprised if the judge had denied it. Mangione got his win. He's got the death penalty taken off the table. The death penalty attorneys are all happy that there's no death penalty anymore. They figured they won. And the worst case is their client goes to prison for the rest of their life. We'll see what they do, maybe go an ID defense or what have you, but the evidence is coming in. Even though the defense had sought to suppress the items, including the handgun, the loaded magazine, the silencer, the handwritten notes, consciousness of guilt, basically confessions, described by prosecutors as a manifesto or diary, arguing that the search violated protocols, lacked a proper warrant, and involved issues with chain of custody and his Miranda rights. Now, like I said, the court sided with the government, which maintained that the initial inventory search followed standard police procedures for officers' safety as well, with a warrant obtained later. They can do that, ladies and gentlemen, although I may just add that I was in court today on a motion to suppress that, yes, we prevailed upon. Yes, we did. Because they can only search the car where the person is under U.S. v. Gant and not the back trunk without permission to do so. No officer safety concerns at that point, and there was no inventory search because they never impounded the car. So, yes, Scott wins, or his client wins. Case is over. Good to go. Anyway, jumping back to the ruling in the Mangione case, it follows a bizarre incident earlier this week when a 36-year-old Minnesota man by the name of Mark Anderson was charged with impersonating an FBI agent in an apparent attempt to free Luigi Mangione from the detention center. Now, Anderson allegedly presented fake paperwork claiming a judge had ordered the release, but the plan unraveled when jail staff requested credentials. He then reportedly warned of weapons in his bag, leading to a search. That's right, officer safety, that uncovered a barbecue fork and a tool resembling a pizza cutter. Anyway, Mangione's federal trial is expected to move forward now, though the exact date for a jury selection has not yet been finalized, but it'll probably be sometime in June or July. Now, just for a quick recap for people who haven't been following this case stems from the December 4th, 2024 shooting of Brian Thompson, on a Manhattan sidewalk. Mangione was arrested days later at a McDonald's in Pennsylvania after customers recognized him. Police say the backpack contained incriminating items. Like I said, the notes, the post-shooting plans, such as avoidance, surveillance, changing transportation modes, purchasing specific items, and checking news reports. Anyway, entries that the prosecutors argue demonstrate premeditation and consciousness of guilt. So I think that turned out just as I had thought it would. The evidence is coming in. Death penalty, not that big a deal. Luigi Mangione will more than likely spend the rest of his life in prison, unless, of course, he gets a really great jury that says, well, if you're a good-looking guy and you went to an Ivy League school, you get a free pass even on murder. I don't think most people will necessarily go there. The death penalty in the federal case, yes, the prosecution could appeal that immediately because it kind of guts their case, and it could go to a higher court to see what, if the lower court got it wrong. And then the appellate courts could say, yes, you're right, it is a crime of violence or should be under the statute, and therefore there is the enhancer for the death penalty. But that's going to take years. It's going to drag everything out. Pam Bondi should just tell her prosecutors to go with what they got and get a conviction. Next, why the multiple perpetrator theory in the Bryan Kohberger case, well, it fails. So the multiple perpetrator theory in the Bryan Kohberger case originated primarily from the work of a forensic criminologist by the name of Dr. Brent Turvey, whom the defense team retained as an expert witness before Kohberger pled guilty. Now, Turvey reviewed the autopsy reports, the crime scene details, and other forensics evidence, and he concluded that at least 2 individuals were likely involved in the November 13th, 2022 murders of the 4 college students there in Moscow, Idaho. Anyway, the simultaneous fatal attacks on Xana Kernodle and Ethan Chapin, who were together in the same second-floor bedroom, which would require rapid, coordinated action to subdue and kill both victims without one alerting or escaping. That was kind of the opinion, right? Anyway, the extremely compressed timeline, approximately just 15 minutes, during which all 4 victims were killed, different floors and rooms of the house. Anyway, variations in the nature and pattern of the wounds inflicted on the victims suggested possible differences in attacker strength, techniques, or even intent. Anyway, these observations led Turvey to argue that a single assailant would face significant logistical challenges in executing such an attack with the reported window. However, this theory was advanced as part of a defense strategy before Kohberger entered his guilty plea. Now, as part of that plea agreement, that removed the death penalty from considerations. He was subsequently sentenced to the 4 consecutive life sentences. Now, several factors render the multiple perpetrator scenario implausible and unsupported by the broader evidence. So, extensive physical and digital evidence linked Kohberger directly to the crime scene, including his white Hyundai Elantra captured on the surveillance video near the residence multiple times that night, cell phone data placing him in the area during the relevant window, and DNA evidence recovered from the knife sheath left at the scene that matched his genetic profile. No credible evidence emerged of additional suspects or accomplices, and investigators focused solely on Kohberger as the perpetrator. Anyway, the forensic death investigator, Joseph Scott Morgan, has mentioned on platforms that he acknowledged the defense's obligation to explore alternative explanations, but emphasized that a single armed individual equipped with a K-bar combat knife capable of both stabbing and delivering blunt force trauma could feasibly inflict the reported injuries in the alleged time frame. Now, he described the weapon as highly effective for rapid, overwhelming attacks, stating that the assailant came prepared and that the notion of 2 persons operating appeared unlikely given the evidence. Ultimately, Kohberger's guilty plea and the absence of any corroborating proof for multiple attackers have led police and independent analysts to conclude that he acted alone in committing the murders. The defense theory, while part of the pretrial preparation, did not alter the case's resolution through his admission of responsibility. Now, the Idaho prison officials have also denied recent reports suggesting that Brian Kohberger might be transferred out of the state due to frequent complaints and prison conditions. In a statement, the Idaho Department of Corrections spokesman Ryan Mortensen said the department is unaware of the origin of these claims and has no plans to move Mr. Kohberger. The Idaho Department of Corrections is not aware of the source of the information and is not considering a move for Brian Kohberger. Now, the speculation arose from a Daily Mail article published Wednesday, which cited Chris McDonough, director of the Cold Case Foundation and a retired homicide detective. McDonough asserted that he had reliable information from a prison source indicating that officials were actively pursuing an out-of-state transfer, potentially within the next month or so. When reached by other news sources, he stood by that particular account, describing his source as solid and even wagering confidentiality on the outcome. So for months, convicted serial killer Keith Jeppesen, known as the Happy Face Killer and currently held at the Oregon State Penitentiary, has publicly suggested that Kohberger should request a transfer to that facility for greater safety. Now, like I said, he's got that, Kohberger's got 4 consecutive life sentences at that maximum security institution. Well, some of his complaints are that inadequate vegan meal options, substandard fruit, such as overripe bananas, and ongoing verbal harassment by other witnesses. He's currently in the J block there, and it's a complete segregation unit that accommodates various populations, including those in protective custody, long-term restrictive housing, and death row inmates as well. Anyway, the arrangement keeps him in separation from the general inmate population. Now, apparently the staff is becoming a little frustrated by Kohberger's complaints, but guess what? They're not going to let Kohberger dictate how they run their prison. Next, the Brendan Banfield case is over. We're just waiting for the jury's verdict. They're deliberating now. The jury has begun deliberating in the trial of Brendan Banfield, the former IRS officer accused of murdering his wife, Christine Banfield, and a stranger, Joseph Ryan, in what prosecutors described as a carefully orchestrated plan to remove his wife from the picture and pursue a relationship with the family's au pair. After weeks of testimony, both sides presented their closing arguments today in the Fairfax County Court. The prosecution portrayed the case as built on solid physical evidence, blood patterns, DNA, and digital forensics that align closely with the au pair's account, while contradicting Banfield's version of events that he testified to in the defense case in chief. They emphasized inconsistencies in his testimony, questioning why he would lie about minor details if his overall story were true, and argued that the evidence left no reasonable alternative explanation for the scene. In contrast, the defense focused on trying to create reasonable doubt rather than proposing a complete alternative narrative. They accused investigators of confirmation bias, claiming the case was shaped around an early theory and then supported by a cooperating witness, the au pair, whose credibility they challenged. The defense described her testimony as influenced by self-interest, including the prospects of reduced punishment and potential media deals. They pointed to gaps in forensic testing, questions the logic of the alleged catfishing scheme for this fetish website, and argued that blood evidence could be consistent with Banfield's attempting to aid his wife rather than staging the crime scene. Now, you can check it out. We brought it to you, but Banfield himself took the stand earlier this week, denying any plot and insisting the accusations were absolutely crazy. He described hearing disturbing sounds from the bedroom, rushing in armed, announced himself as police, and shooting Ryan in what he claimed was self-defense or to stop an attack on his wife. He also downplayed the depth of the relationship with his au pair during cross-examination, though messages between them reportedly include discussions of, having future children. Notably, the prosecution proceeded without waterfall instructions, meaning the jury faces an all or nothing choice on the most serious charges, aggravated murder rather than lesser homicide options. That's, obviously, usually it's the defense that's asking for lesser included offenses, but if the prosecution doesn't object, they come in. And normally, even if the prosecutor does object, if there's a legal basis for it, the lesser included charges. But the prosecutor's like, nope, we're going all in, first degree aggravated murder or nothing at all. He could walk, ladies and gentlemen. Anyway, the jury now holds the decision on the charges, including aggravated murder for multiple victims and murder within 3 years, use of a firearm in a felony, and child endangerment related to Banfield's younger daughter being in the home during the incidents. Deliberations began this afternoon following the judge's instructions, and we'll bring it to you live when a verdict comes in. Next on the docket, yes, ladies and gentlemen, the Epstein files have been delivered. It's going to take some time to go through them, and we will. All 3 million pages. It's going to take a little while to load, I'm sure, but we'll go through them. Anyway, the Department of Justice has released a massive new batch of documents related to Jeffrey Epstein, more than 3 million pages to be exact, along with 2,000 videos and 180,000 images. Now, the Deputy Attorney General, Todd Blanche, announced the release on Friday morning, stating that it fulfills the requirements of the Epstein Files Transparency Act. He noted that while the department collected around 6 million relevant pages in total, the latest drop brings the public production to approximately 3.5 million pages. Blanche emphasized that no materials were withheld or redacted on grounds of national security or foreign policy concerns. The department plans to submit the required report to the Congressional Judiciary Committee detailing what was released Any redactions made primarily to protect the privacy of the victims and other sensitive matters, and the names of government officials or politically exposed persons mentioned. Now, following their early release, including hundreds of thousands of pages made public by the House Oversight Committee back in late 2025, which included troubling photographs of Epstein with young women. Previous disclosures have drawn criticism for heavy redactions, though officials have maintained that these were necessary to safeguard the victims and their privacy interests. Now, being named or appearing in these files does not automatically imply wrongdoing. Many references stem from social or professional connections rather than evidence of misconduct. Okay? Remember that. That's the legal disclaimer there, ladies and gentlemen. Just because your name's there doesn't mean you did anything wrong. So here are some notable entries emerging from today's release. Bill Gates. Yep. He made a big denial. A claim attributed to Epstein's alleges that Gates contracted a sexually transmitted disease from a Russian girl or girls, plural, and apparently obtained antibiotics through Epstein to treat it and intended to administer the antibiotics secretly to his then wife, Melinda. Ooh. Gates has issued a strong denial of these allegations. Prince Andrew. Newly surfaced emails show Epstein arranging a 2010 dinner in London for Prince Andrew, referred to as the Duke, with a 26-year-old Russian woman described as a friend. The exchange includes a response expressing interest in meeting her. Temple on Little St. James. Additional photographs from inside the distinctive blue and white striped structure on Epstein's private island, often called the Temple, have surfaced. The images show a dirty mattress and various symbols, fueling ongoing speculation about the building's purpose since it appeared in drone footage back in 2019. Goldman Sachs. In a 2015 email, Catherine Reiner, then a former White House counsel under President Obama and later Goldman Sachs chief legal officer, referred to Epstein as, quote, wonderful Jeffrey, end quote, and described him as like having another older brother. She has since expressed regret over any association with him and has not faced any accusations of wrongdoing. Then we have Jean-Luc Brunel. A victim described Epstein's associate, the late French modeling agent Jean-Luc Brunel, who died by suicide in 2022, while coincidentally facing rape and human trafficking charges, as 100 times worse than Ghislaine Maxwell in an email to investigators. Other mentions include Epstein expressing a preference against hiring American employees in one email, calling them often trouble. Separately, he offered construction equipment to Richard Branson for rebuilding on a private island in 2017 and claimed in correspondence that David Copperfield and Claudia Schiffer became engaged on his island. Elon Musk was referenced in a 2013 email about a potential island visit, though he's denied any involvement. Now, Ghislaine Maxwell, Epstein's convicted associate, currently serving a prison sentence, filed a habeas corpus petition in December of 2025, claiming that 29 of Epstein's associates, 4 alleged co-conspirators, and 25 others reached secret settlements with the Justice Department or related parties to avoid an indictment. This allegation remains unverified and is part of her effort to challenge her conviction. Now, the full documents are available through the Department of Justice dedicated repository. People are going to continue to review the material, so more details are going to come out in the coming days. It's going to be interesting, ladies and gentlemen. I personally think there's going to be a whole lot of nothing there. I really do. And I know, contrary to what people think, that I know there's, it appears though there's a 2-tier justice system. And if you're rich and wealthy and politically connected, you get a free pass on everything. And well, you may not be wrong, but I think generally in a case like this, they would probably have prosecuted somebody if they thought they had enough to do it, more than just Ghislaine Maxwell. I really do. But for whatever reasons, they probably had some proof issues. And even the ladies that were victimized by him, they were, I hate to say it, not the most credible people and when it came to their memories as to who was there. Anyway, next on the docket, this day in legal history, going old school, 1649, January 30th, 1649, King Charles the First of England was beheaded in London following his trial and conviction for high treason by the parliamentarian forces in the English Civil War. This marked the first time a reigning monarch in a major European state was executed by order of a judicial body representing the people, challenging the divine right of kings and establishing a precedent for accountability of rulers under law. Maybe not the first, maybe the first, but he definitely was not the last, indeed. Next, on this date in 1976, Buckley v. Vallejo, the United States Supreme Court issued a landmark ruling, and in their opinion, the court upheld limits on individual contributions of political campaigns, but struck down restrictions on independent expenditures and campaign spending by candidates as violations of the First Amendment free speech protection. That obviously shaped modern campaign finance laws in the United States, equating political spending with protected free speech. And on this date in 1939, Felix Frankfurter, famous jurist, took the oath of office as an Associate Justice to the United States Supreme Court, appointed by Franklin Delano Roosevelt, and he served until 1962 and became one of the most influential jurists of the 20th century, known for his advocacy of judicial restraint, which means, hey, judges shouldn't get involved in this, incorporation of the Bill of Rights protection to the states, and contributed to civil liberties jurisprudence. Next on the docket, our quote of the day. One of the most prominent statements of humility as it relates to the context comes from Justice Felix Frankfurter in the United States Supreme Court. And in a concurring opinion in the American Federation of Labor versus the American Sash and Door Company, he wrote, quote, "The indispensable judicial requisite is intellectual humility." What the heck does that mean? This concise assertion emphasizes that a judge must possess a fundamental modesty of intellect and awareness of personal limitations, openness to alternative perspectives, and restraint in the exercise of authority. Frankfurter viewed such humility as essential to the proper function of the judiciary, preventing overreach and fostering careful, principled decision-making. See, oftentimes judges think that, well, I've told you this joke before, but I'll tell you again. Do you know what the difference is between God and a U.S. District Court judge? That's right. God doesn't think that he's a U.S. District Court judge. And being a judge sometimes means that you don't have to make a decision because you don't have the actual authority to do so. And you will find there's a little more ego on the district court levels than there is at the appellate. The appellate people are a little more intellectually honest. They look at the cold, hard record. There's not the emotion of the battle in the courtroom. And so that's what Justice Frankfurter was saying is, you got to be wise. You got to be smart. You can't solve all the world's problems. And sometimes you just don't have the authority to do anything at all. Anyway, now that we've solved all the judicial problems in America, let's move on to our dumb criminal of the day. In a bold but ill-fated attempt to win the affections of a dancer at a Clearwater strip club, a 32-year-old Florida man has landed himself in illegal jeopardy after deploying what authorities described as a conspicuously fraudulent currency. Please meet Alexander Baker Depew. Allegedly presented 15 counterfeit $20 bills totaling $300 to settle an approximate $288 purchase of a floral bouquet and chocolates at the local florist. Now, the transaction occurred just days before Valentine's Day, suggesting an early effort to impress the object of his interest. Staff at the shop discovered the deception only after his departure. The bills bore overt markings declaring them, quote, replica notes, explicitly designated for use in motion picture and bearing no status as legal tender, i.e. they were fake. Undeterred, Baker Depew proceeded to the nearby Oasis Cabaret, an establishment billing itself as a venue for topless, full-contact entertainment, where the intended recipient performs. There, he reportedly attempted to cover his bar tab with additional phony $20 bills, prompting club personnel to summon law enforcement. Upon arrival, officers detained Mr. Baker Depew, who maintained that he was unaware of the currency's inauthenticity. A subsequent search revealed roughly $400 more in similar prop bills on his person. When questioned regarding the florist transaction, he acknowledged acquiring the gifts specifically to present to a female dancer at the club. Public records do not specify the nature of any prior connection between the two individuals, and arrest documents list Mr. Baker Depew as having no fixed address. Compounding the charges related to uttering counterfeit currencies, police discovered cocaine and methamphetamine during the frisk, resulting in additional felony counts. He remains in custody on a $21,000 bond. Ladies and gentlemen, this is a cautionary tale. In the pursuit of romance, authenticity is both sentiment and tender, and it remains indispensable. Now, sir, I don't know what you were thinking, but did you really think the dancer at the club was going to go out on a date with you if you showed up with flowers and chocolate? Sir, I can get by with the fake $20 bills. I can. But for you to actually think that the adult entertainer was going to somehow be amenable to your affections, I think you are sadly mistaken. Maybe if you had shown up with some real $20 bills, that would have got her attention. All right, ladies and gentlemen, that's all we have for you today. Thanks for watching. We'll see you next time. Have a wonderful weekend. And remember, the Constitution matters.